My kids are good.
Yeah, yeah.
I mean, on paper, they're great. They're two little white girls in America.
Right.
I mean, what?
Yeah.
I just want to say I'm not trying to say that if you're white, you can't complain.
Right.
I'm just saying that if you're black, you get to complain more. You can't take people's, historical context away from them. And everybody wants us to. White people are always like, come on, it wasn't us. They want black people to forget everything. Every year, white people add 100 years to how long ago slavery was. I've heard educated white people say slavery was 400 years ago. No, it very wasn't. It was 140 years ago. That's two 70-year-old ladies living and dying back to back. That's how recently you could buy a guy.
That is the amazing Louis C.K. Talking about the sort of importance of the context of history. And I think it brings us a broader question about how the court thinks about protecting against racial discrimination and racial exclusion. And there seems to be a debate that the court has been having before Roberts, but now we're going to see it revisited in this term, about, I guess the question is how much you can take race itself into account when implementing policies with the goal of producing some kind of outcome that is either racial equality or diversity or some other compelling interest, right? I mean, that is kind of, am I right that that's the sort of the battle on the table, Dale, in terms of this jurisprudence?
Right. I think the first principle is that you have to look at what the history is first before you start saying we don't want to be race conscious now, right? You played that clip or you read that line from Justice Roberts' opinion about the sordid business of divvying us up by race. Well, that sordid business didn't start with the Voting Rights Act or with civil rights legislation. It went on for decades in the jurisdictions covered by Section 5 of the Voting Rights Act. When African Americans could finally register to vote after 1965, they responded immediately by slicing and dicing African American populations to say, okay, well, maybe you can register to vote, but you're never going to actually elect anyone. And Selma, where Dabo is, the birthplace of the Voting Rights Act, they had to be stopped by the Department of Justice from doing that 5 times in the 1990s. So it's not 400, 700 years ago that we're talking about here. We're talking about just a few decades ago.
And one point about that is that although this is a challenge to Section 5 of the Voting Rights Act, if they think that the Justice Department is being too strict in preclearance, courts are in charge ultimately of the enforcement of that. So if they think that the whole jurisprudence under the Voting Rights Act is too race conscious, too codified, they are in charge of that. They can dial that back. What instead assaulting in this case is Congress's fundamental choice to have a Voting Rights Act. The other thing above and beyond race is this federalism question of treating some states differently than other states, the sovereign dignity of Alabama. And newsflash to the justices, the very process by which the 14th Amendment was adopted was one in which some states, because they had crummy voting rights histories, were treated differently, were required to ratify the 14th Amendment and the 15th Amendment, were required to have public schools
under
forever.
Arms.
Even though other jurisdictions didn't have to have public schools, were required to give blacks the vote before other places actually were obliged to do so. That's baked into the cake. That's part of the DNA of Reconstruction.
This racial entitlement language, this is, first of all, GOP talking points. But the important part is that the Voting Rights Act, that's not about an entitlement.
Right.
It's not like a remedy, and it's also not the kind of remedy we would see in an employment case or in the affirmative action cases. It's actually protection.
Right.
Section 5 stops discrimination before it happens. And I can tell you that when I've done cases under Section 2, Florida, 2000.
Just so we're clear, Section 2, you can bring a private suit after the voting the law has already happened.
Right. And so it is very difficult. Florida 2000, it was difficult. We could not remedy it. Your voting rights have been infringed. Your right to vote is gone.
And you can't go back and rerun an election.
Back and say, President Bush, actually Gore is the guy who should be sitting there.
But part of what this ends up turning on, Dabo, is this idea that I actually think is the wrong idea that seems broadly shared, which is the idea that we're on some sort of trajectory towards some final steady state equilibrium of colorblind equality, at which point things no longer, that the history goes away, or we no longer, we've made progress, and then everyone's sort of we've made progress, but is it enough? And Dabo, I want to ask you, is that the right way to think about it as where we are on some sort of historical trajectory? And I want you to answer that right after we take this quick break.